The case management conference is in the matter of CFI 43/2020 before His Excellency Justice Nasser and is being held by way of video conference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by co-chair and co-legal consultants and the lead counsel is Nikhat Khan. The first defendant is represented by BSA, Ahmed bin Azim and Advocates LLP, and the lead counsel is William Persifka. The fourth defendant is represented by Best Winds Law Corporation for legal consultancy, and the lead counsel is PV Shaheen. Thank you very much.
Okay, we'll start with the claimant.
Thank you. Good morning. As introduced,
I can't hear you very well. Can you either get closer to the mic?
Can you hear me now?
Your voice is a bit far.
Is it okay?
Yes, now it's better.
Okay. So the claimant is a lender known as Bank of Baroda DLC, and we have the first defendant, Neopharma LLC, represented by BSA Ahmed. The second and the third defendant are currently under a stay application, and they are represented by Global Advocates. They were informed about the CMC, but they have, I believe, they have not participated in the proceedings because of the stay application. The fourth defendant is currently represented by Bestwin Law Firms. In terms of the summary of the dispute, the dispute arises out of a facility agreement entered into between the claimant and the first defendant, and corporate guarantees entered between the claimant and the second and the third defendant, and the personal guarantees entered into between the claimant and the fourth defendant, all on 14 September 2017. The claimant claims that, subject to the terms of the facility agreement, it has provided a term loan of around $34 million US dollars, and has the claimant claims that the first defendant has borrowed around 29.729 million as a withdrawal amount and is liable for these sums and certain sums including interest. In exchange for the facility, the first defendant was also obliged to create a possessory pledge of full value of the loan, which was not arranged. And the first defendant was required to make the quarterly repayment, and no repayment was made from 27 February 2020. Because of this, an event of default took place. The first defendant contends that it is not in breach of any agreement with the claimant, as no sums are due and no request was made under the facility agreement. There was no payments made pursuant to a stated mechanism in the facility agreement, and a fraud perpetrated on the first defendant, and which was made possible by the alleged negligent failure of the claimant to comply with the agreed mechanism. To summarize, the fourth defendant's contention is that the fourth defendant states that it did not personally guarantee the claimant's lending facility or sanction letter or facility agreement, any undertaking or guarantee. The signatures of Dr. Shetty, which the bank relies on, are forgeries, and Dr. Shetty did not sign the facility agreement on behalf of any of the defendants. To summarize the procedural history, the claimant has filed the claim around 7th May 2020 and filed the particulars of claim and filed the particulars of claim on 12th May 2020. Subsequently, the particulars of claim were amended to correct typographical errors. And between 27 May to August, all the defendants filed an acknowledgement of service. On 3rd August 2020, an urgent application was filed by the second and the third defendant because they fear that the claimant is going to file a freezing order because around that time, the claimant has sent a notice of non-payment to the second and third and the first defendant. So they feared that because in the previous proceedings, there was another proceeding, the claimant had filed a freezing order. So they feared the claimant is going to file a freezing order. I was not involved in, participated in the application. It was just between the court and the second and the third defendant. So I do not know the outcome of that application. Then following that, I contacted the second and third defendant, confirming that no such action will be taken by the claimant because the matter is now before the court. And so I don't know whether they proceeded with it. Then thereafter, on 6th August, the 4th, we filed an application to amend the statement of claim, which was granted. Following this order, which was issued, the first and the fourth defendant filed a de novo application, which was accepted by the court, and the application of the claimant to amend the statement of case was set aside. Following which, and we had to pay costs for the de novo application, the claimant paid the full wasted costs to the first and the fourth defendant, right from the beginning of the claim to a certain date, to cover all the effort and work done. And subsequently, the claimant filed an application seeking permission of the court and the parties to amend the statement of claim. And under 29 March 2020, a consent order was signed by the defendants and the claimant, agreeing to amend the claim form and the particulars of claim, and following which the parties proceeded with the remaining procedure. That is, on 26 May, the defense and counterclaim was filed by the first defendant. On 14 June, the defense and counterclaim was filed by the fourth defendant. And the reply to the defense was filed by the claimant on 27 June. Now, regarding the CMC order, in principle, it is approved by the parties. We are just waiting for the court to confirm the PTR date and the trial date. Then we can work around the order and decide what we can work around the procedures, and then we will submit it to the court. So we are just looking forward for the court to submit and confirm the PTR and the trial date. Then we will hand over the CMC order. Thank you.
So you're in agreement for the to work out the dates until the pre-trial date and the trial date?
Yes, except for the list of issues and case memorandum, I believe also the parties have as such no objection, but we didn't have time to review because I just handed over to them a week ago. So they need time to look into it. But for the CMC order, we are in principle in agreement. We are working around it. We just want the court to confirm the PTR and the trial date, the judge's availability.
So when are you looking for a trial approximately?
It will be around November 23, because we are busy with another trial, which is going to occupy 6 months of our time.
Don't you think it's a long time, November 23?
Well, I had suggested that we start the process from now, and we just leave the trial to after, because for me, June and July is very busy because I have a trial. But after that, I would be able to do it, but we could complete the procedure.
Why not August, let's assume? Or...
Well, we are fine, but I think one of the defendants is not available.
So you're only available, all of you are available in November?
That is...
Yes, Your Excellency. With the Pacifica for the first defendant, at page B3 of the submitted, B13 of the submitted bundle, there is a draft order, and I can confirm on behalf of the first defendant, subject to the court, that we would agree with the directions set out in that order. And the court will note that that has a trial commencing on the 27th of November 2023. Obviously, that date is subject to the court.
Courts, I think, are okay with those dates. But I think it's a long period. It's 1 year and 2 months, 1 month, around 2 months, actually. 1 year and 1 month, yeah. But if the parties are in agreement with the dates, then I don't think the courts have any issue. Yeah. And is there is an availability on the 27th of November. Actually, 27th of November is close to a public holiday, which is on the 30th of November. There is a public holiday. Then the 2nd and the 3rd of December, which is the National Day of the United Arab Emirates. So I don't think 27 is a convenient date. Maybe a week before or a week after is more convenient.
The first defendant has no objection to either of those dates.
Yeah.
Claimant also has no objection any date after July. I'm fine with it.
And when is the first defendant's counsel available after July?
I could make myself available sooner after July. Yes, I would personally be available in August, though I think it was the claimant's counsel and the fourth defendant's counsel that had suggested this date.
If all the parties' representatives will be available in August, then I think August is a good time, or September is fine too. And you can then work around the CMC if you agree on the dates, working on it until September.
September is very suitable. I mean, considering that we need 2 months at least trial preparation and filing of the trial bundle. So September is also absolutely fine.
September is fine with the first defendant representative and the second and the fourth defendant representative.
Yes, Your Excellency.
What about the fourth defendant?
Yes, Your Lordship. I don't have a problem. September. My concern is only the gap between certain events as suggested in the CMC order. That we can discuss.
The tentative one. I think if we are choosing September as a trial date, I think the gaps should be shorter. Yeah.
It's not about that. In the draft order that was submitted, for example, 27 October is a submission of case bundles to the court. And then 3rd November, that is hardly 1 week, is when the opening statements and written skeleton arguments are to be submitted. Normally, I've always experienced at least a month's time is given. Here it's only a week. And there are very strong contentions in this case.
I don't agree because there is a gap. The bundle was going to be filed earlier, and once the bundle is filed, you will be in a position to file the skeleton argument. So the process was such. Only thing is that what I understand, D4's contention is that they didn't want to file the skeleton argument and the trial bundle together, trial timetable. And my insistence was everything should be over and agreed, even the trial timetable at the time of filing the bundle. Once the bundle is filed, you will have at least 3 to 4 weeks to file your skeleton arguments. Because you know what happens normally, the defendants, they don't agree on the trial timetable and they keep on changing the date, and different counsel approaches me with different timetable changes, and then I'm not in a position to focus on the skeleton argument. So I had insisted that everything will be filed except for the skeleton argument at the time of filing the trial bundle. And then you have time, once the trial bundle is filed, you will have at least 3 to 4 weeks to focus on your skeleton argument. So we will work around this only, agreeing to everything except the skeleton argument, where you will get at least a month after the trial bundle is filed. Because you have to reference the trial bundle in your skeleton argument, so that is a must.
I think a month is sufficient or not.
And now with the trial timetable preponed, we will have very less days to move around. So we will have to work it out. But I can assure, I think the contention of D4 is that they want to focus on the skeleton argument, and I also want to focus on the trial and the skeleton argument. So I'm insisting that the trial timetable, the chronology, reading list, everything should be filed at the time of the trial bundle. And then you have a total period of 4 weeks to prepare your skeleton and the trial.
I think 4 weeks is sufficient or not?
Enough, Your Lordship.
Again, please.
4 weeks will be good enough. I agree.
Okay, you can work through that. Should we work the draft order together, or I trust you with the draft order?
We should be able to agree.
We should be able to agree, I think.
You're sure?
I hope so, yeah.
How long do you need for you to agree on the draft order?
Perhaps we could do it today, perhaps, and
I'll be happy to work it with you.
We don't want to take a lot of time from Your Lordship.
My time is yours today. I'm fine.
We will have a Zoom call again after the CMC, and we will just mutually agree, and they will have the schedule in front of them, and then we can work it out, accommodating each other's request and submitting this hopefully by today.
What about the case memorandum and list of issues?
They need time to review it, but I've taken a copy of from their pleading. I don't see any deviation in that.
I think today everyone should be ready for all this to be discussed.
oh yes, no, we're ready. I mean, perhaps within the amended order, we could set a deadline for agreeing the case memorandum and list of issues.
Yeah. Okay.
And sorry, did you set a date? Did you set a date in September for the trial?
Yes.
I missed it. What is the date for the trial?
No, I didn't mention a date. I just said September for the parties to agree on. Hamad, can you please check the judge's calendar and see when in September is a suitable date for a trial?
All right, I'll check now.
And even for the PTR.
The trial and the PTR, yes. I don't think the court will have an issue in September. Let's just double check if there are different hearings listed in that month or not.
Yes, the week starting 4 September should be all right.
And the other alternative date?
The week right after it should be okay. The week starting 11 September.
So either 4 September or 11 September.
Yes.
7. I think the pre-trial should be, I think,
Could we get back to you on the pre-trial date, because then once we decide.
The pre-trial is either 4 or 8 weeks before the trial,
Yes.
or whatever in between. So
So it has to be in the month of
I
July.
don't think the court has any issue with the pre-trial date.
Yes.
4 weeks or 8 weeks before the trial date.
Okay.
But the rest
In July, preferably I would request once actually the judge has changed the date of my trial, so it will be either on 3rd or it will be on the 17th. So once the court confirms that when the trial is scheduled, I will be in a position to confirm the PTR date.
Okay.
But
It
yes,
should be
we could
agreed
agree
between.
as soon as it's over, we could agree on the PTR.
It should be agreed between the parties, yeah?
Yes.
So when will you come back to the courts with the case memorandum, list of issues, and the CMC draft?
I leave it to the defendants because they need time to review it.
So approximately?
I could certainly come back later today. I mean, however, I'm not sure if the fourth defendant is in the same position. Perhaps on the close of business on Friday?
Before Friday, I mean, end of this week. Is it okay?
Okay. Okay.
Much obliged.
So Friday, by Friday, yeah? No later than Friday. I think sufficient time to review and to decide. Yeah?
Okay. So just to confirm, by Friday before 4 o'clock, the parties will submit the agreed case memorandum, list of issues, and the CMC order.
Yes.
Okay.
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 All good for all parties?
Yes, thank you very much.
Yes.
Anything else?
No, that's it.
Sure.
Sure. Thank you so much.
Thank you.
Thank you.
Thank you.
Bye.